Hello, everyone. Welcome back to another episode of the Divorce and Separation Coach podcast. Today, we're going to be talking about a very sticky subject, inheritance and divorce. Now, I hear this come a lot with many of my clients, and inheritance is something that's very personal. And people feel that money or goods that have been left to them by their loved ones are for them, not for their spouse, especially when they're divorcing. So it can get quite tricky. And it's not a very straightforward answer either, as most of the time in family law. So to talk us through how it works and answer some of those common questions that come up, I've invited Peter Burgess, who is a family solicitor and mediator. He founded Burgess Mee with Antonia Mee back in 2013. And Peter's clients include entrepreneurs, business owners, and people working in financial and professional services, as well as their partners and their spouses. Peter specializes in both high-value financial work on divorce and separation, but also on complex children matters, including cross-border relocation, which is another hot topic that comes up a lot with my clients. So welcome, Peter. Thank you so much for joining us.
Well, thank you very much for having me. This is very exciting.
Well, I look forward to picking your brain on this topic because it's definitely complex.
Yeah, it's not an easy one.
No, it really isn't.
And it's one where people come in with a sort of expectation of a particular answer. And then when you say, as lawyers tend to do, oh, that's a complicated issue, and let me talk a bit. Sometimes they find it quite difficult to understand or to come to terms with, because as you say, it's a very emotional issue.
Yes, absolutely. And we would love all of us to have a very clear answer about things, but it never is quite that straightforward.
It's not that simple, unfortunately.
So should we dive right in? I think that the main question here is, what happens, and I think there's different scenarios, but when you inherit assets during a marriage, what happens upon divorce to those assets? Are they part of the marital pot, or do they remain yours individually?
As I say, it's a question that comes up a lot, and you've said that before, in first meetings, and it's one of the things that people always ask me in first meetings. And to answer the question, we have to go back to the way the court approaches the division of assets on divorce. So our English courts here in London and in England and Wales have very wide powers to distribute property.
Yeah.
And so in broad terms, what happens is on divorce, all of the property goes into one big pot. And the court then decides how that pot of assets should be divided. So the starting point would be, doesn't matter whether it's inherited or whether you had it beforehand or whether you acquired it later on, or whether you earned it, whose name it's in. The starting point is it all goes on the list.
Yeah.
And we have to decide, according to some principles, whether it should be retained by the person who inherited it or whether it's available to the court to be divided.
Yeah.
And there are some, I think you're probably going to ask me some questions about it, but there is some case law about that, about how that works. And it has been an evolving area, as has all of the law on asset division on divorce, for 50 years.
Yeah.
In fact, much longer than 50 years. It's just that the most recent statute dates back 50 years.
Okay. And so I think one of the cases that comes up a lot is people who have inherited goods before they even got married. So, I mean, I had a client who inherited, I think it was 2 buildings from her parents because they died in a car crash when she was a teenager. So she had them way before she was even married. Do those get considered as part of the marital pot, or is it always a case-by-case kind of review?
Well, we have this sort of overarching decisions of the House of Lords and the Supreme Court, which are the top courts in the country. It was essentially the same court. They just changed the name after about 2005. And the decisions that we have to look at to answer that question are the case which is probably still the leading case overall, which is a case called Miller and McFarlane from about 20 years ago.
Yeah.
And that's the case that says when you look at just dividing up property on divorce, you have to look at the 3 strands of fairness. And the strands are needs, compensation, and sharing. And you have to look at the checklist of factors that the court asks us to look at, which are common sense things like how long have you been married, how old are you, what are the resources in the case, what are the financial needs and obligations, and then you have to look through the lens of these different strands. So let me explain a bit more how that works. You might look at an outcome which is based on the party's needs, and that might give you one answer, and then you might look at an outcome which is based on the principle that you share what's in the pot. Yeah. When it comes to the question of sharing, the court does differentiate between assets which are what are called matrimonial, so they're related to the marriage, and assets which are non-matrimonial.
Yeah.
Non-matrimonial assets includes inherited assets. So rewind that for a second, back to what I was saying a few minutes ago. If you have a pot of assets which includes inherited assets, then when you look at the sharing of those assets, the court does share them, but it might share them unequally to reflect the fact that they're inherited.
Okay.
And when you're comparing the outcome on a sharing basis with the outcome on a needs basis, the needs basis will trump the sharing basis. Okay. So to give you some examples, if there's a pot of, let's say, £2 million, and the parties both need £1 million to rehouse, then on a sharing basis, the court will say, this is in very broad terms, they each get half. Yeah. And that's the same, that's likely to be the same, whether or not some of the 2 million is inherited, because the needs outcome trumps the sharing outcome.
Yeah.
If one party needs 1.5 million because they don't have a mortgage capacity, and the other person does have a mortgage capacity, they only need 500,000, you might see that there's an unequal sharing there.
Yeah.
And that will be, again, reflective of the fact that needs will trump the source of the money. The court will just say, well, this is all needed, therefore, we'll divide it that way. But if you've got, let's say, 5 million in the case, and the parties only need 2 of it, and let's say all of that money was inherited, you'd probably see you would see in broad terms, each of them ends up with 1 million because that's what they need. But the person whose inherited money it is also gets to keep the other 3. Okay. So in that way, needs trumps sharing. Yeah. But if there's enough money, if there's a surplus over need, then the source of the money becomes much more relevant. Now, obviously, I do very bold, very sort of bold examples. And the reality is there are lots of other factors the court will look at. And it's a bit more complicated than I've made it in my examples, but you get the idea that the court does pay attention to what the source of the money is. And there's a more recent case, very recent case from, I think, earlier this year, which is a Court of Appeal case. So it's one of the higher courts. It's not the highest, but it's one of the higher courts. And that means that all the high court judges have to follow it. Yeah. It's a case called Standish. Mr. and Mrs. Standish got divorced. Okay. And in the Standish case, the court grappled with the question of whether or not, if you inherit some money and then you put it into your spouse's name, for example, for tax purposes, does that change it from being non-matrimonial, so you can ring fence it and it's treated differently? Does it convert it into being matrimonial and therefore susceptible to being shared equally? Yeah. It's a very long word, matrimonialization, turning something matrimonial. So in my example with the 5 million, let's say that person had inherited the 5 million. Then they divided that into a portfolio, but 2.5 million in one party's name and 2.5 million in the other. In that example, would the person who'd inherited it in the first place still be able to run the argument that they should get the 3 million and the other person, they should share the 2, and so it's 4-1? And what the Court of Appeal said was essentially, yes, it's not about the title to the property. It's not about whose name it's in. The court obviously has to look at where that money has come from. Okay. I mean, again, it's a bit more nuanced than that, but the idea is, I think courts will increasingly pay attention where there's a surplus over need to the source of the money going forward and apply the principle in Standish.
Okay, that's really helpful. So it's not black and white. There's no obvious answer, but in general, the origin is taken into account as long as everyone's needs are covered.
Correct.
And what happens, that's another scenario that's happened a few times with some of my clients, is inheritance coming through during the divorce process, because we all know that can take a while. So, they file and then here they are 2 years later and nothing's been finalized yet.
Yeah.
And somebody comes into some inheritance. Does that now suddenly find itself into that matrimonial pot, or is it excluded because they were already divorcing?
Well, one of the other categories of non-matrimonial property is post-separation property. So what you'd have is something which ticks two of the boxes for being non-matrimonial. But there's an obligation on the parties to disclose any assets which they receive even during the course of the proceedings.
Yeah.
An obligation to disclose goes all the way up until the point at which you have your order approved.
Yeah.
So the person who inherits would have to disclose that they'd inherited it. And on the financial disclosure form called a Form E, which some of your viewers may be familiar with, if they've had to complete the dreaded Form E. Or
unfortunately so.
There's a box which says you have to say what your reasonably anticipated inheritance prospects are. So they probably would have had to have disclosed it. I mean, let's say, for example, that they had elderly parents, or that they had someone who had a short life expectancy and they were going to inherit. It probably would have featured earlier in the case of the Form E, or there might be a question about it. I mean, if it's a sudden windfall, the principle is the same. They still have to disclose, long lost Uncle Tom unfortunately died and I'm his sole heir and I've inherited this money. And the impact of that is dealt with in the same way as it would have been if it had been there from the start, because the court will say, okay, well, this is a non-matrimonial source. Is it required to meet a need? If it's not required to meet a need and it's not been matrimonialized, applying the principles in Standish, it's not been mingled with other money, then, and it's post-separation, there might be even more reason to say that doesn't come into it. So, it could have an impact. I think the other thing to bear in mind is if there's a case in which, there's enough capital to meet the party's housing needs, for example, but it looks like one party's going to have to pay the other some maintenance.
Yeah.
A sudden windfall inheritance might have an impact on the maintenance outcome.
Yeah.
Because let's say that you're the recipient spouse, you're the person that's receiving the maintenance or going to receive the maintenance, and suddenly out of nowhere you get £500,000 landing in your bank account. It would be the case that the court will be likely to say, well, you don't need the maintenance anymore because you have capital that you can live off, and that would help you to transition to being independent.
Yeah.
Equally, if there's a sudden inheritance on the paying party's side, then they were the one that was going to be paying the maintenance. The recipient spouse might say, okay, well, instead of you paying me £3,000 a month, I've got my BDI on the fact that you're now sitting on a pile of cash, and they might want to try to capitalize the spousal maintenance. Quite difficult, a little unattractive to do if it's off the back of someone nearest dying. But that's something that might happen.
And it would have a legal ground to do that. There's a chance it would be accepted by the judge.
I think they would have a basis of making an argument. The judge might think, well, I suppose it depends on the circumstances at the time as to whether the paying party could afford to have that capitalized, or whether there was another plan for that inheritance, or whether, for example, was it going to be passed on to the grandchildren to meet some school fees or other education costs, So there's some flex around that. I think it's more difficult. It's a bit more cut and dry the other way around. If you've got the recipient spouse suddenly receiving a bunch of capital, which wasn't anticipated. But it obviously is all dependent on the circumstances at the time and all the factors the court has to look at.
Yeah, there's all different setups and settings that define one decision versus another. And then also, I guess each individual judge will look at it, from their own standpoint. So there's a bit of uncertainty around that. Now, the other thing that often comes up is your divorce.
Okay.
So you're divorced. Is any inheritance you get after the divorce is finalized completely safe and completely yours? Or is there a chance that your ex-spouse would have a claim to that?
Well, I've given one example of where someone might try and make a claim over it, which is
Yeah.
if the divorce was finalized and there's a maintenance order,
Hmm.
and you're the recipient party to that maintenance, you might come back and say, well, now my ex has got a windfall of £1 million or £500,000. I'd like to capitalise my maintenance obligation. So there is the possibility of doing that. So far as the actual division of,
Sorry, is that for spousal and child maintenance or only spousal?
it's only going to be spousal, unless there's an extremely good reason. It's very unusual to have child maintenance capitalised. Um, and on the basis of the capital division, the capital is usually dealt with if there's been an order approved by the court on a clean break basis.
Yeah.
So the only real exception to what you've just said is if there was disclosure during the proceedings that said, well, I'm not going to get anything from my parents because they're giving it all to the cat's home or the dog's home or wherever they're going to give it to. And then the ink is barely dry on a consent order that the court's approving. And 2 weeks later, the parents die and suddenly there's a windfall inheritance. That might give cause for the person who who was misled to go back and try to reopen the order, but it's a very difficult application to make. And the courts generally regard capital as being something not to be interfered with. I mean, it's a final. That's where we get the words clean break from.
Exactly.
The idea is that you don't come back for a second bite of the cherry on that. So I would say 99% of the time, there's no basis on which someone can come back and make a further claim.
Yeah.
I would say the only other thing that I could mention is in relation to provision for the children. If insufficient provision is made for the children or the children have an additional need which perhaps wasn't dealt with at the time of the divorce, it is possible for a parent to make a capital claim on behalf of a child, even after the divorce.
Okay.
So let's imagine for a moment that the divorce is finalised and that there's a child, and provision is the children's needs have to be dealt with as part of the divorce process. So, but let's assume for a moment something terrible happens and that child suddenly has a need that they didn't have at the time of the divorce. And in the meantime, the father has come into a lot of money. I suppose it would be possible for the mother in those circumstances to make a claim under a separate provision called Schedule 1 of the Children Act for the child, but not for her. So as a spouse, you can't come back. But I suppose there's the possibility of coming back for the child if there's a minor child.
Well, I think it's important to mention actually that in the UK, you can divorce without having a financial order.
Correct.
In which case you are divorced, but you're still financially tied.
Correct.
In that scenario, is it fair to say that inheritance is still everybody's property to share?
Open. Everything's open both ways. I mean, I would always advise, and I'm sure you would too, any of your clients who are going through a divorce, they must have a consent order, unless there's some reason why it would suit them not to have a consent order. But I think certainly if you're acting for the financially stronger party, you want those claims closed off, particularly if you know that at some future date you're going to inherit some money from somewhere. Because until the other person dies or remarries, they can make a claim. They can make a claim against the estate as well. So that's something to bear in mind.
Yeah, absolutely. One last question.
Sure.
I've seen or I've heard of people making interesting arrangements with regards to dividing assets by putting some of those assets in the children's name or giving them as early inheritance to their children. How can inheritance be used in that context to try and, I guess, put some of the some of the marital pot aside for the children later on.
Yeah, and it's frequently a way and a tool in the toolkit for negotiations and so on, where you've got someone who says, well, I'm not terribly happy about giving some of my inheritance to you because we're not going to be married in a short period of time.
Yeah.
And the other person might say, okay, well, if you won't do it for me, would you put some money aside from your inheritance for the children?
Yeah.
Sometimes that's by way of what's called a school fees fund, so a fund that's set aside specifically for the children. And sometimes there are some provisions that say if there's money left in the school fees fund, it'll go towards tertiary education or perhaps a deposit for children later in life. So yes, it's very possible to have that kind of mechanism. And I suppose you have to be mindful of the fact that children can't hold property as a matter of law. So you might be looking at a simple arrangement that says, we'll put money aside for them and we'll manage it until they're 18. Or you might be looking at an arrangement of setting up a trust. The problem with trusts is you would probably want to have a degree of discretion around that trust. And discretionary trusts, due to some changes to the tax regime 15 odd years ago, have complicated tax arrangements and expensive option. But yes, it's very possible to do that. And at my firm, we have a legal director and an associate who deal with private wealth matters. So they're able to give advice and feed into the discussions around structuring settlement to benefit the children.
Yeah. And I can see how emotionally, if you're attached to that money or to that asset, how at least leaving it to your children feels less painful than giving it to your soon-to-be ex. And that could be a really good arrangement if you're trying to secure that for the children.
Definitely. And there are lots of ways of doing it. And I've had clients also undertake to leave their resources in their consent order, undertake to leave by will. So they agree that they're going to leave a proportion of their assets to the children. I mean, the worry is always, well, what happens if I give that person some money from an inheritance and from somewhere else, and then rather than leave it to the children, they remarry, and then their unscrupulous new spouse or new partner spends the whole lot before it goes to my children. And that's very difficult to draft around. I've had various clients over the years try different ways of doing it, but it's not easy. Not least because we don't have a system in England and Wales of forced heirship. So you're not required, as you are in many other continental jurisdictions, to leave money to your children. Although there are some statutory provisions which say that if you're a dependent, you can make a claim if inadequate provision has been made in the
estate. You have to be under 18 then.
There are some ways around it, but it's tricky. But as part of the divorce settlement, I think it's a good suggestion to make, and it can take the wind out of the sails of the person who's objecting, because you could make yourself look quite churlish or mean if you're going to say, well, I'm not giving you any money, I'm not giving to the children either. You're going to win a popularity contest.
So a good thing to think about when people are trying to be creative around their financial arrangements. Just to wrap things up, Peter, it's been wonderful speaking to you, and all the insights you've shared have been incredibly helpful. What would be your top 3 tips if somebody was to take away 3 things from this podcast? How do you protect yourself or your inheritance if you're getting divorced?
Well, I think if you know that you're going to inherit some money, you should have an early conversation with the person who's planning on leaving you the money. Take some advice early on about what to do with it. I mean, for example, you could do what we were just talking about and say to them, rather than leaving it to me, why don't you leave it to the children? And that then moves it beyond the remit of the divorce courts. In a way which is sensible and probably quite difficult to attack. I mean, the family courts have the power to review transactions. So, for example, if someone just before they get divorced gives money that they have already to a third party, the court can reverse that transaction. So there's to be a bit careful about how you do it, but I would have thought it's sensible to have an open conversation with the person who's planning on leaving you some money.
Yeah.
I think the other thing to bear in mind is you could look at a prenup before you get married to protect yourself, but obviously they're becoming increasingly prevalent, or a mid or post-nup. So if you've got a parent who's doing some inheritance tax planning, and they're saying, well, I want to pass down some money before I die, and I want to do it 7 years before I die so I don't pay inheritance tax on that transfer, which is a common inheritance tax planning strategy, then you could think about whether or not, in fact, it's a good idea to put in place an agreement which says if we get divorced, you have a claim on that. I think I've given you three. So the three things would be prenup or postnup, get advice early, and think about skipping a generation. Children.
Yeah. So it all comes down really from thinking ahead and planning ahead.
Planning ahead.
Sure that you're not off guard.
But I'm afraid to say, in my professional experience, most of the time people don't plan ahead.
Yes, and unfortunately, that's why a lot of these situations get quite tricky, because they haven't been anticipated.
Absolutely right.
Well, thank you so much, Peter. It's been wonderful speaking to you. Thank you for your time, and we'll speak soon.
You're welcome. All right. Thanks so much.
Bye.